Hey, it's attorney Ashley Goggins with another Free Game Friday. Happy February. This is our first Free Game Friday of the month. If you are a returning friend of mine, and all of my friends are anybody who watches, shares, comes and learns and gets educated on family law in Florida, go ahead and like this. Tell me where you're tuning in from. Go ahead and share this out with your other friends so that they can become friends with me. I'm going to go ahead and share this out on my page because there's somebody out here that may need to know about father's rights, about family law, or may want to get their question answered here live next week. So I'm going to share this out. Our question today is a little different. Our question today is from a mother. It is from a mother. I didn't put her entire question up here, but mothers, fathers, grandparents, friends, cousins. I get a lot of questions from girlfriends and wives. It is okay to submit questions on behalf of someone else. Hey, the worst that could happen is a no or a non-reply, but it doesn't cost you anything to ask a question. So use www.freegamefriday.com. Answers are here live every single week between noon and now, okay? Between noon and now. Okay, so we got this sharing out with our friends. If you are watching the replay, you can go ahead and share this out with your friends too. Make sure you like our page. And lastly, if you get valuable content from us each and every week, go ahead and write us a review. We appreciate all the reviews. We appreciate all of the referrals. Thank you from the bottom of my heart. Let's get started. I don't want to hold you guys here on a Friday night. As always, it's attorney Ashley Goggins. I'm here in Florida. Anything I'll tell you would be based on Florida law. That is the only state that I am licensed to practice in. If you have any questions about something in another state, I'm friends with so many different lawyers from so many different states. So feel free to send me an email at info@agogginslaw.com if you have an out-of-state question or just need to point you in the right direction. Okay, so let's get started. We're going to read our question for today. It says, my child's father filed paperwork for a parenting plan because I placed him on child support. My child is 8 years old and she cries every Thursday. She's acting out in school and she hates going with her dad because he's mean and he always drops her off and comes back and picks her up late at other people's houses. Can I file to get another hearing so that I can modify time sharing? Okay. First things first, what happened is the father was placed on child support by the mom, okay? And what happens is when you're placed on child support, as soon as you get served, you do have the right, this is for my fathers, you do have the right to open up a case in circuit court. Now, if you have been served, you have 20 days to open up a circuit court case. If you do not, you will have two cases going on at the same time, okay? You can also be put on child support before your time sharing plan is put in place. You also can be placed with arrears and retroactive child support before you get a parenting plan. So you want to make sure that it's all done at one time. So he decided to do a parenting plan once he was served with his child support papers. And this is just a hypothetical. Hypothetically, he got served within 20 days. You know the 20-day rule, you guys. Within 20 days, he decided to say, you know what? I want time sharing with my child. I want to be able to see the child when I get ready. And what a lot of people don't know is when child support is calculated, it's calculated based on the mother having 365 days. This is why men end up paying so much in child support. The number one reason why is they don't respond. The second reason is that the calculations are based on how much time you have with the child and how much money each parent makes, okay? So if you don't respond, they're either going to pull your records from wherever it is that you work that is reporting to SunTax, which is the system that the Department of Revenue pulls your income from. She'll respond, and she's going to put all of this information on her financial affidavit, which is turned in at the time that she petitions for child support, okay? So she can put on there that her child is 8 years old, but she's paying $500 in daycare. fees. Okay, so you have to respond so that you can contest. And then the biggest thing is the retroactive child support. It can backdate for 2 years. Now, what if you have a really good paying job now, but you don't have a really good paying job? You didn't have a really good paying job 2 years ago. Likely, my good friends at the Department of Revenue are going to use your new job and they're going to backdate it 2 years. Imagine that. So, okay, that's neither here nor there. It's a whole nother Free Game Friday. This Free Game Friday, this father said, you know what? No, ma'am, I don't have time for that. I want to see my child. So he has time sharing with his child. And it looks like per what she's stating in here is that he has the standard time sharing plan. The standard time sharing plan is one night during the week, and it looks like his night is Thursday. If you guys can't agree, it's usually Wednesday. However, in Duval County, if you agree to whatever day, that's what day they're going to decide, whatever day. If you can't agree, generally it's going to be Wednesday. So he has Thursday. And then he'll also get every other weekend, okay? And returns the child. Well, this mother wants to change it. Now, this is the lowest you can get as a father in most cases, unless there's some type of abuse or some type of reason why the father should not have the minimum time sharing plan, which is one night during the week and every other weekend, alternating holidays, okay? It's between 112 days, just about 112 days a year, right? So say for instance, and I'm combining a couple things. So generally when your child support is calculated, it would generally calculate the father at 0 and the mother at 365 days. But when he gets 112 days and she gets, I'm not good at math, I think it's about 266. When she gets her days, it kind of, it reduces his child support obligation because he now has some days, at least some days, okay? So he's exercising his time sharing, and he probably got a reduction in child support because he did that. Now mom says because her daughter, and what do we want to call the daughter? Let's call her Nene. No, I don't like Nene. Sound like she don't like going with her dad, but that's okay. Let's just call her Nene. Nene does not like to go with her dad, Day Day, because Day Day drops her off to his sister's house or to his friend's house or to whoever's house, and they don't like giving little Nene any snacks, okay? And she doesn't have a cell phone because her daddy doesn't pay enough in child support to get her a cell phone, and the mom is not going to use her child support to buy the little girl a cell phone. So she can't call her mom or text her friends or none of that when she's with her daddy or at her daddy's friend's house. So she is upset now. She's upset now, and she doesn't like going with her dad at all. Mom wants to change the time sharing plan. Please let me know in the comments if you guys think that she should be able to change the time sharing plan based on these facts. I'm going to tell y'all the law. I want you guys to tell me how you feel, okay? I need to know in the comments. She should be able to change it or no change. So say change or no change. Or you can put your favorite emoji. You can do the emoji lady that says no, or you can do the emoji lady that says yes or thumbs up. So should the mom be able to change the time sharing parenting plan because the daughter no longer wants to go with her dad? She cries when it's time to go. She doesn't like that he takes her to someone else's house during his time sharing. On those grounds, do you believe? Let me know in the comments, and I'm watching you guys. No change. So as you guys are coming in, the law states, so once you get a final order, whether it be a final order from a divorce or whether it be a final paternity order, we call it like a final judgment. Once the parenting plan is in place, it goes to a final judgment. Any change would be a supplemental petition. So if she wanted to make a change in the parenting plan, she would have to allege that there's a substantial change in circumstances. This is what the law says. There has to be a substantial change in circumstances. And a substantial change in circumstance here in Florida is a material, unanticipated change, okay? Material, unanticipated, substantial, okay? It's a substantial change in circumstances, okay? It needs to be material and it needs to be unanticipated, okay? So I'm going to tell you guys, if a judge saw these facts, they would likely say that that's not enough. That's not a substantial change in circumstance to make the switch, unfortunately. Unfortunately, it's not. Because, and the reason why is it's all about the best interest of the child. But, you know, children, they change. You know, sometimes they like their dad. You know, when we were younger, sometimes the child liked their mother more, you know, especially as young girls. Sometimes we wanted to be with we couldn't stand our mom at some points, and we wanted to be more so with our dad, and then vice versa. If you had a relationship with both parents. But children are so temperamental, they go up and down, up and down, up and down, up and down. So something like that here in Florida would not survive a motion to dismiss. So if that was served and he hired me, I'm going to play a devil's advocate. If he hired me, I would file a motion to dismiss solely on the basis that it's not a substantial change in circumstances. So there's no material change. And it's so hard to overcome. Everything is fact specific, okay? Super fact specific. I have had cases where obviously there was an abandonment issue. I've had cases where there was abuse allegations. Things like that would be considered because you don't anticipate that that will happen. You do anticipate that a child will grow, the child will be of age, the child's needs may change. If a child were to become disabled and their medical needs may change, then that would be considered a substantial change in circumstance. Does that include overnight stays? What about first right or refusal? Well, if it was negotiated in their final judgment, a lot of times if these parties were doing it by themselves, what I've seen commonly when people come to me for modifications, I don't see the first right of refusal in the final judgments. However, when both parties are lawyered up, or at least one party is lawyered up that wants the right of first refusal, that is in there. So that is something that we could ask for, is having the first right of refusal. But that still, wanting that would not be a substantial change in circumstance that would be unanticipated and material. So basically materials like major change, not anticipated, you couldn't have thought about it at the time when you were doing the final judgment. That's why it's important to get what you want and anticipate what might happen in the future, although you can't for everything. You can't anticipate everything, but at least try to have a whole, complete final judgment that protects you in the future. Does anybody have any questions about that? Again, guys, make sure you share, comment. We have some more comments. Make sure you share, comment. Let me know if you have any questions, follow up to anything I said. Remember, you can always ask your questions, submit them anonymously at freegamefriday.com. If you know anyone that needs assistance and has a question, you know, all questions don't require a lawyer, but I will say family law is super, super fact specific. So if it's something, you know, real quick, just go ahead and shoot it. It could be a good topic. A lot of questions people ask the same thing. This modification is very common. People wanting a modification and thinking they can just go in court and make a change. Well, it's hard to overcome the burden, because the burden is a lot higher because they want the children to have stability. Now, if there are some allegations like the children are failing, the parent does not exercise time sharing with the child at all, but don't wait until it's years and years and years to have the modification. Make sure that when there is a consistent change in circumstances and it's a major material change, that you reach out to a lawyer early on. Then by the time you reach out, the situation may not be the same anymore. So it's no harm in just checking to see if this would warrant a substantial change in circumstance. Thanks, Kristen. Me and Kristen went to law school together. Hey, girl. All right. So I'll see you guys again next Friday. Remember, like, share, comment, let your friends, your baby daddies, your boyfriend, your husbands, anyone you know that may need family law assistance, please remember to go with Goggins. Give us a call, schedule a consultation with us, 904-903-4522. I will see you guys next Friday. and you can submit on the link at www.freegamefriday.com. Bye.